everything, including that which would have caused it to not be suitable for the master. So that you would need the 42 to grant the decree absolute. If not the 27, just starts it. But the master, as I understand this, is to be able to grant the 27 and 42 in uncontested applications, which cover everything, including children, well, all that would allow you to get a divorce, which would deal specifically with the children. Now, I know and I notice that subsection or subclause 2, for the purpose of paragraph 1, the master is hereby authorized to transact all such business and exercise all such jurisdiction as may be transacted or exercised by a judge in chambers, which I take to mean that she can do the 42, or no, I'm saying she, but that's because our current master is a female. So subclause 2 seems to address section 42. I'm just wondering if we have subclause 2, why we needed subclause 1, and if we have subclause 1, why we don't have reference to section 42. If that could be answered, I would be grateful, Mr. President, because it seems as if there's either something missing or there's something too much. Because as I said, as you know, sir, the divorce is section 7, pursuant to sections 27 and 42 of Chapter 2.1 for the Family Law Act of Barbados. So I just wanted to know, and that's what stood out to me when I was reviewing this legislation. You're giving her power to do 27, but not power to do 42, or is that supposed to be caught up in subclause 2? But if it's caught up in subclause 2, why do we need subclause 1? Just for completeness, sir.
Does it simply mean that only the judge in the end can give you the 42, which is the stage 2, which is in effect?
But that's not what has been happening, and as if this legislation is supposed to be giving her the powers of the judge in chambers, and if this legislation is seeking to regularize that which has transpired in the past, which is divorces have been granted by the master pursuant to both sections, then please clarify even further for me, sir. Because right now, I don't know as we speak, but right now prior to dealing with this, the master has been granting divorces pursuant to both sections 27 and 42.
Yeah, but does it not simply mean that only the judge can pronounce the divorce? That is section 42.
Is
But
that
the
what we're
master
doing?
Can do
Yes.
the section 27 and all the ancillary work related to that.
But why are we, but if it's uncontested, why do we need to come back before a judge when we could do 27 and 42 before the master, who is supposed to have similar powers to a judge in chambers, and if divorce is contested, which probably means that you have submitted an agreement, or that you don't have any children involved and it's a straightforward divorce between a man and woman with no children or no issues. Why would you need to have to come back before a judge?
It would be 5 minutes only.
No, but you would have to come back, sir, because if you get the 27 on one day before the master, you get a date of hearing 9 months later before a judge. Why would we need to do that? That seems to be adding to the process rather than fixing the process and making the process more tedious. Right now, a master can give you an uncontested divorce 27 and 42. If what you're saying is correct, and I'm just seeking clarity. I'm just seeking clarity from where I can get the clarity. It seems to me that what we need to be doing is either giving the master the 42 power, or we don't need subclause 1. That's my humble opinion, but I would like clarity from those who would have had access to the policy decision. With that, sir, I'm much obliged.
Thank you. But perhaps, it simply means that only a judge might be able to pronounce you divorce.
Kevin?
But an officer at a lower level can deal with all the other issues.
Okay, right. Kevin Boyce.
Yes, Senator Boyce. Thanks.
Thank you, Mr. President. This morning, or this afternoon, sorry, sir, the debate relating to the family law amendments, and as we seek to facilitate our mortal desires and put things in place to solidify certain steps that were taken, it is understood the need and necessity for the provisions which the government is seeking to pass today, sir. Certainly, the master currently plays an integral role in relation to the administration of justice at the court, sir. A role which should be enhanced and encouraged if at all possible. Currently, we only have one, and maybe with two and further augmented powers, we might see some assistance rendered to the increased judicial officers which will be in place with the new divisions which are supposed to start in January, sir. My understanding is that there will now be a family, a commercial, a civil, and a criminal. If the masters are increased and given more powers, as is currently being done to rectify, we may find that some of the interlocutory applications which tend to clog the wheels of justice, Mr. President, some of us may use them for tactical purposes. Some of us may use them to get to the actual truth of the matter. Who knows? But perhaps if we were given more resources to allow that process to be a little quicker and diverted from the judges, who can then focus on getting to the meat of the matter, we may find there is some increase in the resolution. But of course, wishes and horses, we recognize the obligations in terms of finances which any increase would bring. It occurred to me, sir, like my friend and learned senior Senator Tate, that we should, with your indulgence and with that of the other members of the Senate, take a moment to reflect on the loss of Beverly Lady Waldron QC, sir. And recognizing that in these moments, you will hear the cry that the lawyers always speak to their own. But certainly in a context where we're debating family law and legislation which seeks to improve that process, the fact that Lady Waldron would be unable to see the benefit of it, I think compounds the tragedy of her loss. I was speaking with another senator this morning who informed me, and I wouldn't call the name because it was a personal reference, that Lady Waldron QC, in every capacity where she met on the Council of Legal Education and the Judicial Services Committee, in those aspects spoke incessantly of the wish for a family court. And I thought it, sir, again with your leave, and so it is recorded for posterity, that I record the statement issued by the bar in relation to her passing, so that those who ever find themselves researching this issue in the future may perhaps have a small glimpse into a person who gave a lot to the area of family practice and to the country as a whole, Mr. President. Mr. President, the statement from the bar is as follows. The bar is shocked and saddened by the loss of our friend and colleague, Beverly Lady Waldron QC, in such tragic circumstances. Lady Waldron has been a stalwart of the legal profession, first in Jamaica and for decades now in Barbados, a country she has embraced wholeheartedly. She was a former president and long-serving council member of the Barbados Bar Association and a member of the Council of Legal Education. As a practitioner, Lady Waldron was well known for her civil practice and even more so for her family law practice, both for private clients and as counsel and advisor to the Child Care Board for many years. In all spheres, Lady Waldron was committed to promoting the best practices and traditions of the legal profession and advancing the interests of the bar. She always encouraged young attorneys at law, providing gentle guidance when needed. She was also always one to speak her mind without fear, knowing that she held the courage of her fiercely held convictions. This is a loss beyond measure. She will indeed be sorely missed. The bar extends sincere condolences to her husband, Sir Errol Waldron, and their children, Maya and Maurice, and their grandchildren. May she rest in peace. Mr. President, there are a number of tributes that were paid on social media which reflect Lady Waldron's love of family law, her encouragement of the younger practitioners, and her energy and her commitment to the Child Care Board. She was a former president of the Barbados Bar, and her continued efforts with regard to the development of family law. If I may, the only personal reference I would like to give, sir, is that on occasions when we spoke, because I dare not venture, Mr. President, into those hallowed family law halls, sir. You know, we civil practitioners tend to hold our lane when it comes to our areas of practice. But every once in a while, I will find myself with Lady Waldron outside the courts, waiting for very short periods, of course, Mr. President, waiting to be heard. And our discussions tended to flow along the lines of family. And my fondest memory of her was that she gave me a recipe for Jamaican red peas soup. And while that may not seem something that should be referenced, I think it speaks to the duality and her ability to bring a touch of wholesomeness to practice and her engagements with persons from all walk of life. Lady Beverly Waldron, sir, is someone who will be sorely missed, and on behalf of the Senate, as well as the practitioners, as well as the citizens of Barbados, I would like to offer our sincere condolences to her family. And sir, to bring it all to an end, we must remember that the purpose of the legislation which we are seeking now seeks only to ratify that which was being done. So it's a question, and we can discuss de facto and de jure, and whether or not what was in place and what was right and what was wrong. At the end of the day, sir, these persons believe themselves to be divorced and to have a divorce that was granted by the state. I don't think that anyone in their right mind would seek to bring any harm upon them from that fact, and I think we're all in support of the remedy which is being proposed today, sir. Actually, sir, the circumstances may find it that persons who were not divorced before this bill is it proclaimed, or before this bill is officially granted, may take the opportunity, if they find the need to beg back is the colloquial, or to put themselves in a situation to make wrong things right. At the end of the day, it is legislation which I will have no issue supporting, and I thank you for your indulgence this afternoon. Thank you, Mr. President.
I can't see my light.
Senator Greenwich.
Thank you very much, Mr. President. Mr. President, when we hear of divorces, invariably we think of the husband and the wife, and we reflect on the fact that the marriage has broken down, and these two will now go their separate ways. What we do not stop and consider very often is the fact that there are certain issues which have to be attended to after the divorce. In particular, sir, the children. The maintenance of the children. This is one of the problems that we have at the end of the divorce. How is the husband, usually it is, going to support those children? How much money per week or per month will be paid for each child? Also, the whole question of visiting rights. What is termed access to the children? Will the father be allowed to take the little girl to his home from Friday evening until Sunday morning? All these things have then to be settled. Of course, there's the whole question of property. What about the house that the two of them signed this mortgage for? What is going to happen now? Is the house going to be sold and the property, the proceeds of the sale, divided between the two of them? Or is one going to remain in the house and pay the other one out? So at the end of the divorce, the point I'm making is that there are quite a few issues which have to be settled. And therefore, when you heard Senator McConney referring to the Section 27, the marriage is broken down. The Section 42 is the one that deals with all of these other things. And believe you me, these things can be very, very complicated, extremely complicated. You can have a situation where this case can go on for 3 and 4 years before the 42 is granted. And you can imagine the stress that that couple lives under in the same house. In the same house. For 3 years, 4 years. Because the Section 42, the property and so on, that has not yet been settled. So it's not just the fact that the marriage has broken down and they told them not speaking to one another anymore, but it is these issues at the end of it. Now, the judge, usually a judge in our court system, the judge hears these matters and the judge decides whether it's a 50-50 split, a 60-40 split, whether the agreement to see the child will be such and such. The judge listens to evidence, whether it be by affidavit or whether you go in and you give your evidence from the witness stand. But the point is the judge hears this evidence and the judge makes the decision. Now, we're dealing this morning with a situation where the master formally dealt with divorces where you had no such problems. You had just a matter of the marriage has broken down. There were no children. There was no property settlement to be decided because most likely they were renting or whatever. But the point is, she dealt, well, I said she, like Senator did, because the master is female. But that is the problem, that she had, there you go again, the master had this job of dealing with these uncontested divorces. And it was a simple thing. You could do it, I could do it, so anyone could do it. You didn't have to go to law school to decide that our marriage is broken down, irretrievably, there are no children, therefore you're divorced. You didn't have that problem at all. Anybody can do it. It was a simple, simple matter. And that is what the master had to do. Now, these cases were assigned to the master. And I do believe, sir, that over the years when the master dealt with this particular problem, that there would have been hundreds of cases that went before the master like this. There would have been quite a few. Because, believe it or not, the divorce rate in Barbados is high. It is high. Now, during the time that the master was dealing with these particular problems, sir, the judges never complained one day, 1 minute. that the master was stepping into their territory and that there was something wrong with that. Never, never on a single day did you have a judge complaining. The couple, the divorcees who got divorced by the master, neither one of them ever complained that the wrong person did their divorce. And needless to say, there was never a single appeal by any divorcee which the master dealt with that I was unfair or anything of the sort. Sir, lawyers never complained that the wrong judicial officer dealt with the matter. And the master never complained that she was overworked and that they were giving her too much to do. Everyone, every single person, sir, everyone was happy with the way that those non-contentious divorces was handled. Everybody was satisfied. So the impression should not be given that the master did something wrong and that this is a way of getting back at the master or punishing the master or anything of the sort. Nothing like that. In fact, when I first heard of the problem, my first reaction was that the first thing we should do, yes, is to validate what had happened before, but that we should go on from there. And whether separate or otherwise, legislation should be given to take care or give the master the green light to continue to do these uncontested divorces. That was my first reaction when I heard of it. Even before this particular amendment came, in other words, it coincided exactly with what I was contemplating. That these uncontroversial divorces should be part of her duty. And I have to say here too that the masters that I know of Keith Roberts, Mr. Keith Roberts, excellent, did an excellent job as a master. Excellent job. I know of Miss Deborah Holder, continues in the same vein, doing an excellent job. So there can be no real criticism that they didn't know what they were doing or anything of the sort. These are two hard-working people. As I said, they went beyond the call of duty. Miss Weeks, that was it. Yes, she also did a good job. Yes, sir. All of them that I've worked with, master always. And sir, yes, all divorces will now be done, and I'm thinking of these, the ones, the contentious ones, they'll be done by family court judges. But I would like to make the point, though, that family court judges, they become ill sometimes too. And family court judges go on vacation too. And that from time to time, we will still need to have the situation where judges outside of the family court can be allowed to do these divorces. And I wouldn't be surprised if they're called upon from time to time to do divorces and family matters. And the master herself can be called upon, as Senator Tate suggested, to do the Section 27 and the Section 42 in cases where there's no controversy whatsoever. Mr. President, I also want to make the point that during the time that the master functioned in that capacity, the master took a lot of pressure, a lot of stress off those judges. And it is a point that we have to realize and we have to acknowledge it. We were complaining a lot about the backlog. And I'm telling you, were it not for the function performed by the master in those divorces, that backlog would have been worse. I reiterate, sir, that had not the master done those uncontested divorces, the backlog in our courts would have been worse. And the way that the master functioned, the way the master worked, it helped significantly with that backlog. Sir, only this morning, I looked at the case list because I have a little marriage. Maybe I have to run off and go to court with this at lunchtime. I saw about 25 family law matters before one particular judge. 25 family law matters before one particular judge.
So destructive.
Yeah. And that judge was not the only judge doing family law or with family law cases before him. Other judges had family law cases before them as well. So you could imagine the volume of family law cases that we have in our courts. And sometimes you sit and you wonder, why is it that there's this ballooning of family law cases in Barbados? Sir, one school of thought is that we have made divorces in Barbados too easy. Too easy. Parties nowadays, sir, are more tempted to jump off the marriage train than to make the marriage work. There are young people, sir, who are not at all willing to compromise in any way. Not prepared to compromise in the way that my grandmother and my mother did. Not this young generation, sir. We've made it easy. We've gone to something called no-fault divorce. And sir, with no-fault divorce, one party only has to say, one party, not both, only has to say, this marriage has broken down irretrievably. That's the end of it, you know. That's the end of it. In my mother and my grandmother's day, sir, you had to come with fault. You had to say there was desertion, there was cruelty, there was adultery. Not now. All you have to do is to say the marriage has broken down irretrievably. That's the only reason you have to give. So there are those who have said that divorces, yes, have skyrocketed since no-fault divorce came into being. And I can tell you, sir, that when I started to practice, sir, family law was merely simmering. It was merely simmering. Now it's boiled over. It's boiling over. True. I have a little note that I had made even before Senator Tate spoke. It was a note to just say speak about the loss of Lady Waldron. And I had reflected here that family law had boiled over to the point where I knew of 3 lawyers in particular. Their practice, each practice, is at least 90% family law. Some as one of the 3, perhaps as much as 99% family law. And they are comfortable with that. And it gives you some indication as to the amount of family law that they have on their desks. A lot of it. They hardly worry about other legal matters. No, sir. Sometimes, it takes a real man to tell a story or to make a point that puts other men in a bad light. But I believe so that if the real man does not tell this story, then it leaves quite a huge chunk of our story untold. And we have to speak about certain things. Yes, Mr. President, no-fault divorce is responsible for the increase in the number of divorces on the case list. But, sir, even more important has been the independence of thought, coupled with the financial independence of the Barbadian wife today. That too is responsible for the skyrocketing of divorces. Sir,
Brave man.
let me tell you,
Brave man.
you gotta be a real man to say it, yes. You gotta be a real man. Sir, when I was at school, I can only speak of my district. When I was at school, sir, I remember well, there was one gentleman in that district who had 6 children from his wife, 6 more from another woman, just a few yards down the road. Yeah. And worse than that, I wanted to be like that man. I used to say so because he was a fella, he was a, yeah. But no, he was a real man. But not no, sir. But so some of those same children, one would have been born like the 16th of January and the other the 18th from the 2 separate people in the same year. In the same year. They were running side by side.
You were telling stories.
Yeah, and indeed it was to the extent, sir, that when you asked for him at home, the wife would say, he ain't here, he down home. And when you asked him down home, the lady would say, he ain't here, he up home. That was the kind of relationship. And I knew another man, sir, in the same district, who had 2 from his wife and 5 from the outside person. And don't talk about the ones that had just 2 or just 3 from the wife and 1 from here, 1 from here, 1 from here, 1 from there. Yeah. Those things happened. Now, sir, the point I'm making though, it may sound trivial and people might laugh. But the point I'm making is this. None of those wives ever left or got divorced. That is the point I'm making. That is the point I'm making. The point I'm making is that none of them ever left and none of them ever got divorced. You think that could happen now? No. You think that could happen now? No. Never. You see, sir? So those Barbadian wives depended, those Barbadian wives then depended to a large extent for everything from the husband. This way spoke about the financial independence and other ways of today's wife. They couldn't even get a lawyer on their own or couldn't even think about it. Not today's wife. This is something completely different. And those wives of yesterday were willing to put up with the infidelity, willing to put up with sometimes verbal abuse from the husband because they felt themselves hemmed in and had nowhere to go. Today, sir, as I said, today's wife would remove themselves from those unfortunate situations in a flash, and file for divorce, and there would be yet another divorce on our case list. It would be. So, sir, I still consider, sir, that the area of family law is perhaps the fastest growing areas of law in Barbados, if not the fastest. And it will continue to be so as long as you have relationships between husband and wife. It will continue to be so. And I believe it will be so, sir, as long as the world lasts. As long as the world lasts. I support the amendments, I support the remedies, and I thank you, Mr. President, for your indulgence. Thank you very much. Comments.
Senator Lisa Cummins, please.
Thank you very much, Mr. President. I think I'm coming at an appropriate time in this debate, Mr. President. And I want to first, of course, support this particular bill. And I want also, Mr. President, to say that in Barbadian parlance, we typically have a saying, which I'm going to put in the Queen's English. It says, cockroach does not have any right at foul cock dance. I'm saying that very properly. And we're surrounded in this chamber by learned attorneys at law who have expanded in great detail, very ably, on the merits, the legal merits of this bill, Mr. President, the role of the master, the role being played by the judge, sections 22, sections 47, I believe Senator Tate went through them in great detail. And so I will not and cannot find myself in that space. But I wish, Mr. President, to speak on the implications of the bill on the construct of another important entity in our society, namely the family. And I want to, in the course of my conversation, Mr. Deputy President, speak specifically about a number of concepts that have become very important, and I choose my words carefully, even more important in modern terms. The notion of patriarchy, questions relating to misogyny, Mr. President, the notion of the traditional woman versus the modern woman, the real man versus the weak man, Mr. President. I would wish to spend some time, Mr. President, on those concepts, because in some instances, they are key to the questions that we're facing in the family law courts, Mr. President. We have not just an increase in the number of divorces, as has been articulated by Senator Greenidge in his own contribution, but we have seen, Mr. President, the rise of a number of groups in this country called things like Me Too, Life in Leggings. We've seen globally the rise of these kinds of groups simply because, Mr. President, patriarchy as we know it to be, misogyny and sexism in many instances as we know them to be, are all alive and well. And each time I see a woman murdered by a spouse as a result of an abusive marriage, that financial dependence caused her to be in a position where she was unable to leave, I contemplate on the notion of the real man. Mr. President, each time I see a woman who is facing emotional or physical abuse, verbal abuse even, and is unable to leave her matrimonial home because all that she has historically known is dependence on her husband for her own survival and that of her children, I think about these concepts, Mr. President. And I think about the importance that even though we would wish to see a reduction in the number of divorces, I think about the importance of the family structure and male-female relationships in their traditional and in their modern context, Mr. President. Now, we are in a modern era which shines light on many of these issues. We see many young women also. We're not only talking about the wives in these relationships, whether they're up home or down home. We see also the children who are products of these relationships, who struggle. Mr. President, we live in a country a lot of times where each time a young woman, young girl, goes missing from her home, we think she's all shacking up with a man. We dismiss her sometimes to our own detriment, I think, as a society. Because we have missed our own analysis, Mr. President, of the many homes, marriages, husbands and wives, mothers and fathers in a home, who, because of their inability to be compatible, or to the extent where a marriage has broken down irretrievably, irreconcilable differences, Mr. President, you have children in that home who themselves are struggling with that conflict and who run from that conflict to where they can consider to find that they may find safe haven. Mr. President, there are instances where we have many of our children who are running not just from conflict in homes, but sexual abuse in a home. And in those circumstances, Mr. President, there is no ideal scenario, but certainly making your way to the court, whether to your attorney, through your attorney, who then takes it all the way through, and you find yourself presenting to the master or a judge as you've outlined, and you find a way forward that is suitable to peace, Mr. President, that brings peace of mind, peace in your home, and allows you to rebuild a life in some instances, Mr. President, for you and for those children. That becomes the only scenario that is on the table. And that is why, Mr. President, I stand here as a woman who is financially independent, and I make bold to say that there will never be a moment that I will stay in a home where I am verbally, physically, or emotionally abused, or where my child or children, Mr. President, are verbally, physically abused, or living in a situation of conflict. No. That will never be the case, Mr. President. And one of the key underlying factors we have seen, not for the retention of the marital structure, but for abuse, Mr. President, has been the lack of financial independence for women. I see so many people who reach out to many of us on a day-to-day basis who have nowhere to go because they have no means to look after themselves. I know, Mr. President, what it is like to go through a divorce. I stand here not just as a financially independent woman, but as a woman who's been through a divorce. And I know when I made the decision, it was not a light thing. It was not a light thing, Mr. President. I made the decision, however, that it was the right thing for me at that time, and I have never regretted the decision subsequently because it was the best thing for us at that time. But what I also was conscious of, Mr. President, was that children, the notion of staying together for the benefit of children is also something that has to be considered in this divorce conversation. When children grow up in healthy, happy households, Mr. President, Mr. Deputy President, they see that as an example of what they themselves aspire to. When children grow up in conflict-ridden households, they see that as something to run away from. When children see fathers having multiple women and multiple children, and mothers having multiple relationships and coming and going, they see that. On some level, they recognize that, Mr. President, but when we look at our wider society and our communities, we are also conscious that many of our young adults have struggled with broken homes, have struggled with examples that have been laid in them through their mothers and fathers. And I think, Mr. President, that this is an important context for us, that we need to be saying to our people, get help. Find counseling services. Find that counselor who can work through with you what your issues are. Approach those issues with a certain level of commitment to finding resolution. Commit to finding emotional intelligence and find solutions, Mr. President. But most importantly, if you are a woman in particular and you are in danger, get help. But what is most important, Mr. President, and we have seen it in many of the murders that have happened in this country and elsewhere, is that it is at that moment where a woman seeks help that she is most vulnerable. It is at that moment when a woman seeks help or tries to leave that abusive home that she is most vulnerable. And it is in that moment that she is most likely to be killed by an abusive spouse. We need to have systems in our country that allow for women to have safe haven where they are in those circumstances. And I'm looking forward to not only the expansion of the criminal system, the family law system, the civil law jurisdiction, and all the courts that Senator Boyce mentioned earlier that will allow us to cover these cases, but also the social infrastructure that goes along with supporting the individuals that have to encounter these various environments, Mr. President. Now, I need to make 2 more points. When a family goes through a divorce, property is one thing. But again, those children, this morning, many of us who were here early were standing around looking forward to seeing our youth marching through Bridgetown against violence. And many of us, even though we physically were not able to be there with them, stood with them in support and spirit because they were marching for an important cause, Mr. President. But our children are products of our society. Our children are responding to the things that they're seeing in our society, either to speak out as advocates against those things, or in some instances to be the victims of those things, Mr. President. When a family goes through a divorce, and I want to speak to the wives and the husbands in particular who go through these processes, your children are not to be weaponized. They are not to be weaponized. Children are not to be used as weapons and tools to hurt one person because you feel that the relationship has deteriorated beyond the stage where you can manage it. Mr. President, when things were good and you thought you were going to spend the rest of your life with this person or you were going to build a life with your person, you made adult choices. You made mature choices that suited you and your partner at the time, your husband or wife. When that is no longer the case, and that is life, it can happen. Your children are not meant to be subject to your emotional choices. The fact that you no longer love Joe or John or Joe no longer loves Jill or Jane, has nothing to do with your responsibility that you have now assumed as a parent. And I want to say, Mr. Deputy President, that very often and too often, the courts are used as a tool to frustrate and to torment wives and husbands as a result of children being weaponized, whether by way of access to those children, withdrawing access, or by way of maintenance and support of those children. The courts are being used as a mechanism to weaponize our children, Mr. President. And I'm calling on mothers and fathers, get help, seek mediation if need be. You cannot have a circumstance, because I'll tell you, there are many women out there who, if a former husband has not put that maintenance in the account or has not put it in her hand or something like that, will determine that access is equivalent to maintenance. But in that child's mind only knows mommy or daddy. That child only knows, I want to see my mom or I want to see my daddy. And while you as the adults have to battle that out, access to a child should never be linked, Mr. President, to anything other than the fact that as a parent, that is your responsibility to nurture, to care for, to provide for that child. Equally so, oftentimes, Mr. President, maintenance is used also as a weapon. If we're agreeing today, if we're not agreeing tomorrow, if we're getting along today, if we're not getting along tomorrow, then I'm not providing money. That is what determines whether I'm going to provide maintenance. But there's something, Mr. President, and I remember some time ago, a few years ago, there was a former leader who made a comment about single mothers. And I remember being very disturbed by it, Mr. President. What is a single mother? When two families have separated, when a family has separated, two people who are married have gone their separate directions. Mr. President, the parent with primary care and control as awarded by the court on any given day takes responsibility for that child. When the school calls, they call you. When the child is sick throughout the night and doesn't see, you're the one who's present and doesn't sleep. When the child is hungry and they come home from school, Mr. President, you are the parent of primary care and control on the ground every day. If you don't have it, sometimes a parent may say, I don't have it this month, or I don't have it this time. But that parent with primary care and control doesn't get to say that. That parent still has to find it. That parent still has to put food on that table and clothes on that back. And we have to be able to come to a place in our country where, and I have seen some men in particular do this, who say, look, my child's needs cannot be legislated or cannot be regulated by a court. Because I know what my child is accustomed to in terms of standard of living. And if my child needs a pair of shoes, I don't have to go back to the court agreement to determine if I'm going to pay for that agreement, for that pair of shoes, Mr. President. Because that is my child. That is a real man. That is a real man. Or if the father is a parental person with primary care and control, that is a real mother, real woman. You take responsibility for your children, whoever you are, and whatever your legal status is, whether you are divorced by the master or not divorced by the master after this bill has been passed. You take responsibility for your children, because we are damaging too many of our young people as a result of this. And Mr. President, my final point is this. I would like to see a moment where, inbuilt within our legal system, is a social care system that allows us to work through the issues that families as a whole are having. And when I say that, Mr. President, I mean in this case, you have some parents who, for all intents and purposes, are functioning. They're functional, but they're dealing with some real deep emotional issues. You have a recent conversation about high rates of suicide among some of our young men. What's happening in their homes, Mr. President? What's happening in their relationships, Mr. President? We have young women who are also struggling with different types of issues. What's happening with them? You see people sometimes 10 years after a divorce, 15 years after a divorce, as angry today as they were when they first got divorced, and they haven't gotten past it. What is your emotional people to a stage where they demonstrate a certain level of emotional intelligence, healing, restoration, and the ability to move on when they come through a broken family? And I think that's an important part of the entire family law discussion that I would love to have incorporated into these new structures, so that we're focusing not just on the legal granting of a divorce, whether it is nisi or absolute at the second stage, and whether we're talking about the provision of the institutional arrangements for a number of courts being put in place, but we're also talking about making that which is broken whole again. And in this instance, I'm talking about our men and our women who become husbands and wives, and the children that they produce out of those relationships, who in turn are either emboldened or broken by our own failures as adults. And with those few words, Mr. President, I'm obliged to you.
Senator Rogers.
Please proceed, Senator Rogers.
Thank you very much, Mr. President. And thank you for granting me the opportunity to speak on this bill for just a short moment. Like Senator Tate, it was not my intention to speak on this bill. And like Senator Cummins, it's outside my depth to speak of the legal aspects of this bill. But what I wish to add to is the debate that has been placed around the table here about the nature of marriage, and as Senator Greenidge would have outlined, the prevalence of divorce in Barbados. I wish to first state from the outset that marriage is primordial. It does not belong to any religion. It does not belong to any culture. It is God's gift to humanity. What has happened over time is that various cultures, and in our case, our state, has set some parameters to determine what marriage is and within what context it will take place, who can be married, etc. And so what we're discussing here in terms of divorce are really stipulations placed by the state and conditions placed by the state for persons in unions. But as I usually tell people when they come for preparation for holy matrimony, that marriage is not an event, it's a process. And the process would have started long before they came to me. And by God's grace, it will continue long after. What they're coming to me to do is for me to act in the capacity as two persons in one, a minister of religion to ask God's blessing on their union, and a marriage officer of the state to oversee the legal aspects of it. It is within that context I wish to speak to some of the things that Senator Greenidge would have raised when he outlined what Barbados would have been like in his time growing up. There are two reasons perhaps why Barbados was like that. Barbados emerged as a slave society in which our men were studs, used to produce the strongest workforce possible. And in fact, it was only after the abolition of slavery that they sought to force people to marry in mass. So we're just a few generations past abolition, and there's really not a very strong tradition of marriage, even within the Caribbean context. I think when this bill was being debated in the other place, they mentioned quite often Edith Clarke's work, My Mother Who Fathered Me, which is a Caribbean reality. But also compounding the tradition of Barbados is that Barbados was grounded heavily in an Abrahamic faith tradition and an Old Testament perspective particularly, where women were chattel. Women were either the properties of their father or the properties of their husbands. And the importance for the community was the security of the woman's womb. And the man had control of the security of the womb. The man determined what will happen. And so even if one were to read the sex laws in the book of Deuteronomy, for example, Deuteronomy 23, where it speaks about the rape of women, the rape of virgins and betrothed women and married women and so on, the problem is not the rape. The problem is what it can cause to the man and his image within the society and what it can cause to family. It has very little to do with the woman and the woman's rights. And so the high rate of divorce in Barbados, though it has been highlighted as a negative thing by Senator Greenidge, may actually be a sign of our liberation as a people, where our women are now claiming their rightful place as equals to men. A sense of gender equality which the church has recognized. So when one looks at our marriage rite within the church, one of the first things it says in the introduction, the union of husband and wife in body, mind, and spirit is intended by God for their mutual joy and fulfillment, for the help and comfort given one another in prosperity and adversity. Mutual joy and fulfillment. This is far removed from what was perhaps perceived in the time that Senator Greenidge would have spoken about. Because for those of us who grew up in any village setting, you would know that there was a saying that women used to tell their daughters or their granddaughters, "You're getting married, he's a good-looking fella. When he calls, answer. When he calls, answer." That means when the man wants sex, make sure he is satisfied. That was a part of our tradition. That was a part of our tradition. And I'm sure that though it was meant to be comedy, we can recall the song by Rudifus, Days of Our Lives, the Mad Comedians. How he came home and the woman is watching TV, she hasn't cooked anything, and he wring his hand in her jawbone and the false teeth drop out. And he tell her, go to Dr. Horton and put them back in. You see, these were some of the images of marriage that existed in our community. I think now we're having a sense of gender equality where women recognize their rights and recognize who they are, and the strong man will recognize that as well. Perhaps if we want to look at the divorce rate negatively, it may have more to do with an aspect that the church has also recognized in its right. And the church says, in marriage, husband and wife give themselves to each other and they begin a new life together in the community. It is a way of life that all should reverence, and therefore it must not be entered into carelessly, selfishly, or wantonly, but responsibly, honestly, and after serious thought and prayer. It may happen, for example, as Otis Redding's mother, not Otis Redding, Percy Sledge's mother told him, take time to know her. That some persons may not be taking that time and then find themselves in a situation before the court. Or some marriages may be those of convenience, similar to what the Mighty Sparrow would have sung about in Mr. Walker. She ugly, yes, but she wearing them expensive dress. People say she ugly, but the father full of money. And so you come to see your daughter. I've said all of that to say, sir, that we're in an era of gender equality, where women must be recognized as our equals in our union. And I believe what we may be experiencing is the residual where some are still stuck in an old system of expectations of women, of things that pertained a long time ago before they were perceived as our equals. In fact, the church also recognizes that, because even in our vows, we do not stipulate to obey, and neither do we say anymore till death do us part. The church's vows now say, I, A, take you, B, to be my husband or wife, to have and to hold, from this day forward, for better, for worse, for richer, for poorer, in sickness and in health, to love and to cherish for the rest of our lives, according to God's holy law. It's almost like an exit clause. According to God's holy law. If that is not there, everything else falls apart. And the same thing for exchange of rings. I give you this ring as a sign of our marriage. All that I am, I give to you. All that I have, I share with you, within the love of God. Within the love of God. If that is not there, everything else falls apart. And so for persons listening to this debate, I do not want persons to leave with the impression that the institution of marriage is useless or weak. But the institution of marriage must be grounded somewhere. And the church has it that it ought to be grounded in a relationship first with God. And that is what is meant by being equally yoked, that the persons are on the same page and God is their guiding force in their relationships. And so in relation to this bill, we understand that many persons may find themselves before the law courts for divorces, but that may not necessarily always be a negative thing, because one of the things, I always infuse an element of sobriety when I'm speaking to young couples. Come preparing for marriage, they come with the stars in their eyes and looking forward to the wedding day. But there's an element of sobriety that I tell them that I do not, and the church does not, encourage persons to stay in relationships that are killing them. Be be it physically, emotionally, spiritually, or otherwise. Because personally, financially, you have already promised for better, for worse, for richer, for poor. You can't get out of that. But I would rather be performing a service in church with two people sitting, one in the front and one in the back, because they do not want to be close to each other, than to be performing a service with one in a coffin and the other at dogs. So I wish to support the amendments made in these bills that would afford persons easier access and easier process in the court system, but I also pray for all those couples that may be experiencing challenges at this time, that by the grace of God, they may be able to restore their bond and move forward in life. Thank you very much.
It's hour and 10 minutes.
Mr. President, I almost don't want to go to lunch, sir. This has been such an exciting debate. But at this time, I know that they're waiting for us, and so I beg to move, sir, that we now suspend for lunch and return at 2:30 p.m.
The question is that we now suspend the session for 1 hour and 10 minutes and return at 2:30. Meanwhile, we have our lunch. All honorable members in favor, please say aye.
Aye.
Those against, please say no. We think the ayes have it, and we are now at lunch until 2:30.